Merci pour l'invitation, particulièrement à ma chère amie professeure Laurence Boisson de Chazournes. C'est un grand honneur d'être ici au Collège de France. J'ai honte que je n'aille pas parler en français. J'essaie de parler très bien dans ma tête. Et seulement dans ma tête, malheureusement. Pardonnez-moi. J'ai promis moi-même que la prochaine fois que je suis inventée dans un environnement français, je vais présenter en français. Mais pas aujourd'hui. Alors. Oui. C'est un devoir. It's not a right yet, but maybe someone else's obligation to make me keep to my promises. Right. How can international law recognize rights of nature? And it was already announced with a question mark, and you will find me asking more questions than presenting answers. And every time I talk about this subject or I think about this subject, I am setting out to finally give the answers, and then I end up with more questions than before. And that's the same today. Maybe the title is already not entirely correct, asking how can our international law recognize rights of nature? Maybe why? Why should international law recognize rights of nature? And Sasha dit, sont-ils nécessaires? Well, yes, are they necessary? And for the domestic level, I would say certainly yes, and also for the international level, but maybe for different reasons. So this is more or less the structure of the yet a bit unfinished paper, and I will, this is the introduction already, but for the other issues, I put up just 2 questions per topic on the screen, and I will elaborate a bit on that. And I think you will see clear the connection between all the different panels. So there's clearly the connection, of course, Sandrine, to your presentation, but also to the second panel when we talked about, or the panel talked about human rights and the environment. So that's where I started from, was to ask, well, what's the relationship between international human rights and rights of nature? Because sometimes it's presented as if there was or there should be a transition. So now we are coming closer to the human right to a clean and healthy environment, and then rights of nature would be the next step. I'm doubtful if this is really, if there is a continuous line towards something different. I think we need both. I think we need the human right to a healthy and a clean environment, and we also need, or it's not exclusive, mutually exclusive, to also have rights of nature on the international level, because, well, human rights are inherently anthropocentric. I mean, that's the purpose. And I think it's a difficulty for the environmental problems that we face to, at the moment, have to individualize this in order to make a claim at a human rights tribunal. I think the common interest, the common good, where you then have to show that you as an individual suffer in order to make a claim, I don't think this is, in all cases, the right way or the best way. At the same time, I think we need this approach, but if you have to show the connection, if you don't have an actio popularis where an individual can claim for the community, then the approach is rather limited. Whereas rights of nature on the international level would be ecocentric, naturally ecocentric in nature, and could make different claims. And I think, again, referring to the second panel, these 2 approaches come together where we have group rights, where we have rights for indigenous communities to not only claim for their own, maybe religious or traditional rights implications, but also as a kind of a guardian, a custodian for nature. This is where these 2 approaches merge or could be merged. So as a very short conclusion here, I think it's not the next step. It's something that should be explored in parallel. And this is also, Sandrine, why I liked your list of where, what kind of transition do we need? And you listed rights, animal rights and rights of nature. And so a list of different approaches that are not exclusive. So having said that, the question still remains, of course, do we need rights of nature in the international level, and what kind of rights of nature could we possibly need? Where does international environmental law reflect rights of nature? Well, not explicitly. So we talk a lot about rights of nature on the national level, and all the examples, or many of the examples, and the countries that include rights of nature in the Constitution have been named today. International environmental law, hard law, doesn't do that yet, we should say. We have a lot of soft law instruments, like the Global Framework for Biodiversity that has been named, where explicitly reference was made to Mother Nature. But if we, as a first step, look at the hard law, well, we have the recognition of an intrinsic value of biological diversity in the very first sentence of the preamble to the Convention on Biological Diversity. But again, the preamble isn't binding. It's guiding the interpretation. And we don't have any recognition now in the new draft instrument for the BBNJ. We don't have any mentioning of an intrinsic value of marine biological diversity. We don't have a recognition of a right of marine biological diversity to be protected. And as far as we have a common concern or a common heritage of humankind in treaties, I think they're not really equivalent to a right of nature. They could be interpreted to go in that direction, but the common concern is human concern, or the concern of states, but states don't as such have a will or concern. It's human concern, a common concern, but not really recognizing a right of nature. And likewise for the BBNJ draft, the mentioning of the common heritage of humankind, that at least implies in a second step we have some kind of trusteeship. So again, a connection to the rights of nature debate. The reference to the common heritage of humankind in the draft for the BBNJ refers back to the Law of the Sea Convention, and we can then debate whether this would inherently limit the common heritage of humankind to the seabed and to mineral resources. So far, lots of mentioning in then soft law, particularly the latest example, the Global Biodiversity Framework. But again, with this reference to Mother Earth, the reference to different value systems on the national level, that could then, on the level of implementation, be very valuable to put into action what the Global Global Diversity Framework foresees, but not really a transition of a common recognition of rights of nature for the international level. Otherwise, of course, an ecosystem approach and so on. You can if you look hard for some evidence where a right of nature on the international level could come from, we find certain steps, but in the end, it is rather than instrumentalized towards human use, human benefits. So from the perspective of formal substantive rights, it might also be questionable if on the international level this could be more than symbolic, because that's usually, if you talk about rights of nature, lots of people will say, that's symbolic. It's nice to talk about Mother Earth and the planet, but does it really help? For the international level, I would say yes, in the sense that if we recognize rights of nature in a substantive way, the question of procedure then would follow, because the next question would, of course, be, well, who would then represent nature? And would it have personhood and representation? And if we have representation, then, well, representation where? And we could go on to procedures, and courts. So in essence, it would add another player and maybe put another player at the table of negotiations and also in front of courts and tribunals. I also asked my question here whether, when we have just again heard from Philippe, the droit et devoir, and the paper on the European level was also, I think, Sasha, included in your presentation, where authors say, well, as long as we have obligations, we don't really need the rights. The rights are inherent. If we have obligations, then there must be rights inherently somewhere on the other side of the coin, so we don't need to spell them out as long as we have the obligations. And this may work for the supranational legal order of the EU, because we have very clear obligations with thresholds and timetables. It's less so on the international level. And I think here the difference between national legal orders, the EU level, and public international law become particularly apparent. Of course, we have obligations on the international level, the obligation to protect the marine environment, Article 192 of the Convention, and customary international law, maybe even with the function of working erga omnes. But it's an obligation of conduct. It's a due diligence obligation. We don't really know for sure what it means. And I think here it is much harder to say just because we have an obligation, there's also some entity that has rights. I think for the international level, this would be more difficult to argue because you need so many steps in between to actually define the obligation before you know what kind of right is somewhere included. And it would be more than symbolic and easier, it's not the right, it's not really a legal term, it would be easier if we had substantive rights with personhood and someone who could actually represent that right and then at the same time also shape the obligations and assist negotiators, legislators, and courts with defining such obligations. So we move on to legal personhood and representation, and the first, well, I have to maybe tell a little story because it's also, for me, it's a process of thinking and a process of changing my academic mind on the issue, because about 10 years ago, a colleague of mine and I myself got a call from a non-lawyer, but working on the ocean, saying, oh, look, there are now rivers who have legal personality. Could the ocean be a legal person? And without much thinking, my colleague and I just said, no, this doesn't make sense. What would that be? And what would that help? And the ocean cannot be a person. A couple of years later, I gave a lecture at the International Ocean Institute at Dalhousie University on a memorial lecture for Elisabeth Mann-Borghese. And I thought, when I prepared that, I thought, oh, if there would have been one person to represent the ocean, that would have been her. And she would have been such a great guardian or trustee for the ocean. And that already changed my mind. And now I'm here arguing that maybe, yes, that was really a good idea to have the ocean as a legal person, to have it represented and intervene in court proceedings. So this is just, but also maybe in an academic life, the time span that it takes to bring some ideas forward. Legal personhood and representation are not at all foreign to public international law. We do nothing else. States are represented. States as all the subjects, except for the individual that slowly has partial personhood in public international law. Everyone but the individual is not a natural person. It's an entity of different degrees of an artificial construct that is then being represented from states to international organizations. And I would argue, well, it's not at all foreign that other entities, like natural entities, could gain personhood and be represented on the international level. More difficult it is to say, well, what natural entities, if we talk about rights of nature? I've just said the ocean, the climate, biodiversity. But as soon as we come to entities under national sovereignty, we have issues. And it's no coincidence that you find the common concern in the Biodiversity Convention, but not the common heritage of humankind. Because states were conscious, due to the permanent sovereignty over natural resources, that someone else would say, oh, look, that's also our heritage, it's the heritage of humankind. We are going to tell you what to do with your resources. We'll have the same issue here. If we said, well, rights of nature for the rainforest worldwide across the different continents, states would not be happy. Let's put it very cautiously. So would that make sense at all? On the international level, while we do have natural entities that go beyond, or that does either are completely outside national sovereignty by definition, the deep seabed, the high seas would be regions where by the existing law they have been placed outside national jurisdiction. We would have the atmosphere, we would have the climate as entities, it's not the right term for this, but as something that is so far beyond the state and so all-encompassing that states would not claim national or exclusive rights. Or we take the planet, Mother Earth. So I think that's a crucial question in this context for the international level. It's easier on the national level with a river, but already if you have a transnational river, you have different interests that need to be balanced. Next question, who would represent them? Well, Elisabeth Mann-Borghese for the ocean would have been perfect, but would that at all be a single person? And would we have one person for each entity, or would we have one person for the planet, or would there be a commission or an institution? So that's an important question. Or would we entrust different environmental NGOs with particular procedural rights to represent nature? This is something one would need to think about. I do not have any answers to that yet. In any case, I don't think it could be a single person, that's quite obvious. But in any case, if we had a small commission or a small institution, what would be absolutely vital would be scientific information. So scientific, and Philippe has just referred to it, would have to go into this representation, what kind of information, social, religious information, in this case here, in any case, scientific information would need to go into that, because to speak for the climate or for the forest, if you look at the, for the ocean, if you look at the reports by the IPCC, or if you look at the reports on the state of the ocean, it's quite evident that any decision or any intervention on behalf of such a natural entity would need to be based on sound information to put to the table what's good for that entity. Procedural rights in international adjudications. We're coming already a bit towards the end before I present at least some answers to some of the questions. Would natural features have standing? And the article of 1972, should trees have standing, has already been cited several times today. Would natural features have standing before international courts and tribunals? Maybe we don't need to go all the way. What I would argue for would at least be a right to be heard. And we could take it from the right to issue an amicus curiae brief to a right to be heard, in the sense that the court or tribunal has to take into consideration the intervention. Not to agree, but at least to take into consideration. Amicus curiae briefs you don't even have to take into account. You can take it as information, you don't have to. The next step would be a right to be heard, a right to be taken seriously in our court proceedings, up to intervening as a third party to a dispute, up to being able to initiate a dispute. Lots of changes for all of these steps, except for the amicus curiae briefs. You would need to change the statutes of international courts and tribunals. And certainly, if we had an entity representing the ocean or the climate that could sue certain states for not meeting their obligations, as we all know, states would need to agree to such change, and we would not get there. But maybe some of the steps up to there could already make a difference. What could be the role of advisory opinions? Well, we see a rise in environmental questions of advisory opinions, and again, a reference to the BBNJ draft, where the conference of the parties to that new instrument can request an advisory opinion from the International Tribunal on the Law of the Sea. Whether that would then be on environmental protection or rather of access and benefit sharing for genetic resources, we'll see. So, but I think if we had a recognized representative, guardian, trustee of natural entities on the international level, the right to request an advisory opinion at either of the international tribunals for the law of the sea or the ICJ could make a difference. It would come within in a certain rise of such advisory opinions that are taken seriously. With that, I'm already coming closer to my conclusions. So international law obviously does not yet recognize rights of nature, but to answer the question why, before I come to the how, why, I think it would be beneficial with all the limitations that we have, and I think it could be more than just symbolic if we really think about a transformation, because as Sandrine said, there's no lack of international environmental law. We have, usually when I talk about this law of the sea, people say, oh, yes, the high seas are kind of a black hole, there's no regulation. There's a lot of regulation. It just doesn't seem to help. I mean, we have the Convention on Biological Diversity and action plans and targets, and now the new framework. We've had that since 1992. And still we are this century, or the centuries of the huge biodiversity loss. So there's no lack of law, but there's a lack of puissance. And so maybe fostering rights of nature also on the international level could be one way or one path to make a transformation to more effective mechanisms on the international level. Notwithstanding that in the end it's always the will of the political actors, which are by now the states, they would also need to agree to give rights to entities of nature to be represented. So an international human right to clean and healthy environment, and we're getting more closer to that, and rights of nature are not mutually exclusive. The latter is not a further development of the former, and I think we need them both. Particularly also because in the human rights debate, of course, you will need to balance. There's not only the right to a clean and healthy environment, but there are also other human rights, and it has been mentioned today, that would be balanced. The right to property, for example, that would be restricted by rights to clean and healthy environments. You would always need to do the balancing between different human rights, whereas for a right of nature, the weight of that right would be higher than the human right debate, where you need to weigh different rights against one another. I think that obligations under international environmental law in most cases are not strong enough, not clear enough to reflect, to include rights of nature on the other side of the coin. So I don't think there are some already there inherently hidden. I don't think this is enough. I think we need them explicitly to also shape the obligations. So again, this works into both directions. Obligations giving rights to an entity and defining the rights of the entity, reflecting back on the obligations, for example, if we have due diligence obligations. There are different models, obviously, for representation, but I would not question the capability of legal personhood. I think that's quite clear. And so this is clearly possible. We would not just need to define, would that be an ombudsperson, a trustee, a commission, an international organization there for me, I mean, would go a lot of bureaucracy again into that. I'm not sure. In any case, scientific information and advice would need to go into that representation body. And last point, international procedural law could, in theory, offer lots of different opportunities for inclusion and representation. And I think here it would be good to start slowly from amicus curiae briefs to a right to be heard, and then see where this takes us and make use of the possibility then to have advisory opinions. And that's all from my side. Merci beaucoup. I'm looking forward to your questions.
Merci beaucoup, Nele. Tu as souligné beaucoup d'obstacles à la possible reconnaissance des droits de la nature en droit international. On va voir ce que cela provoque comme commentaire, mais j'aimerais demander à Philippe et Sacha quelle est votre réaction par rapport au paysage juridique dressé par Nele sur la possibilité ou l'impossibilité du droit international de pouvoir accueillir les droits de la nature en droit international.
Ok.
Approche.
En résumé, j'aurais tendance à dire que la question, c'est de nouveau la même chose. C'est que pour toutes ces questions, ce qu'on a besoin, c'est de pouvoir cesser de considérer le national et l'international séparément. Donc on a besoin d'une approche graduelle du local à l'international, et je crois que c'est là où on a le problème principal, c'est qu'on en est toujours en grande partie à devoir considérer les choses séparément, et du coup on est toujours à ce moment où il y a des choses qui vont bien au niveau national, puis tout d'un coup au niveau international on a un blocage complet ou important.
Merci.
J'ai vraiment été très, très impressionné par cet exposé. Je crois que je voudrais rebondir sur la question de la représentation de l'océan, en fait, dans sa totalité. Il se trouve que c'est un sujet qui m'intéresse beaucoup. Je pense qu'il y a plusieurs stratégies possibles, en fait, et elles ne relèvent pas toutes nécessairement du droit international. Il y en aurait qui relèveraient, par exemple, du protocole de Nagoya, et qui seraient en fait des compléments possibles à apporter au protocole de Nagoya, en disant par exemple que dans les aires au-delà de la juridiction nationale, Area Beyond National Jurisdictions, la notion de provider qui s'applique au contraire dans les aires où il y a des États qui provident par exemple des ressources génétiques marines ne s'applique plus tout à coup dans ces aires-là, parce que ces États c'est un autre régime de patrimoine commun de l'humanité qui apparaît là. Or, ça serait intéressant, mais c'est vraiment un exercice conceptuel et presque philosophique que je suggère ici, de récupérer quand même cette notion de provider, mais de dire que cette fois-ci, c'est l'océan lui-même, la mer elle-même, qui est provider. Et donc, c'est comme si on donnait un statut juridique particulier, là, à un niveau très international, justement, où le droit des États simplement en eux-mêmes ne s'applique plus, mais c'est un droit international vraiment qui s'applique, et d'appliquer les notions par continuité qui s'appliquent dans un cadre national ou multilatéral à un cadre véritablement international. Et donc, du coup, par là, de donner des droits déjà quasiment définis conceptuellement, mais à l'océan, cette fois lui-même. Et j'ai d'autres stratégies à proposer, mais je vais m'arrêter là.
D'accord, merci. Merci beaucoup. Je pense qu'il y a peut-être des gens qui vont vouloir intervenir. Moi, je voudrais aussi poser... Nele m'a fait réagir parce que, finalement, quand Nele identifie les éléments de la nature, c'est des éléments génériques. C'est l'atmosphère, c'est les océans, c'est... les forêts tropicales, et je me disais qu'on a déjà des instruments en droit international qui identifient des sites naturels particuliers. Alors je pense à la Convention de l'UNESCO de 1972 sur le patrimoine naturel et culturel, où il y a maintenant nombre de sites naturels qui sont protégés par la Convention de 72. Je pense aussi à la Convention sur les zones humides d'importance internationale, où on identifie des zones humides d'importance internationale, d'importance pour la communauté internationale, qui sont protégées. Et là, il y a à la fois le droit national et le droit international qui jouent un jeu. Et je laisserai à Nele le temps de répondre, mais je me demande si, au lieu de passer par la voie du générique, on ne devrait pas passer par la voie de sites spécifiques, de ressources spécifiques, et tester la possibilité de la reconnaissance des droits de la nature au plan international.
Can I answer to that? Yes, sorry. Yes, you're absolutely right. Of course, we have certain conventions where states have agreed to make certain sites natural heritage, for example. But in this case, I've asked myself whether that would then really go beyond the international level, because on the national level, that's also what states do in respect to rights of nature. And if these specific sites would have legal personality also on the international level, I'm not quite sure. Well, for the zones humide, I didn't think about them because they have relevance for the planet as such. The question for other sites would be, well, against whom would they try to defend themselves? If we have a national park, for example, it was that's where my thinking started. It would rather be like a human right against the state. But in this case, potentially our states would have their own mechanisms under national law already. Beyond, could certain sites or zones humide, or well, maybe tropical forests, make claims against the whole of other states? It would at least facilitate, if they had legal personality, to be heard in proceedings. That could be an idea, but in the end, I think the first step would be that states would actually need to agree to these zones under their jurisdiction having some kind of legal personality, either on their own state level or beyond. That's a good. I noted it. I will put it in the paper.
Merci. Est-ce qu'il y a des commentaires ou des questions, des apports? Oui, il y a une...